Aaron, just let me know when you're ready.
Yes, sir, Judge. Judge Martin,
Yes, ma'am.
we have Miss Kelly Coffey and Mr. Merleader.
All right, this is cause number CR20-236, State versus Kelly Coffey. I believe we are entering a plea today. Is that correct, Ms. Merleader?
That's correct, Your Honor.
All right, and Ms. Heisel, can you give me the terms of the plea?
Yes, Your Honor. Upon a plea to the lesser included possession of a controlled substance, PG1, under 1 gram, state jail felony, state's going to recommend punishment be assessed at 18 months TDCJ, state jail division, with a fine of $1,000, $180 restitution to DPS, $290 court costs, and $765 reimbursement with 33 days jail credit.
All right, and Ms. Coffey was originally indicted with a third-degree felony. Is that correct?
That is correct, Your Honor.
Okay.
Oh, you're right. Judge, this was filed by information, and Ms. Coffey has waived indictment in this cause.
And she has filled out the waiver of indictment. Is that correct?
Yes, Your Honor. It's in the plea packet.
All right, Ms. Coffey, if you will, raise your right hand. I'm going to place you under oath. Ms. Coffey, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Ms. Coffey, every individual in the state of Texas who is accused of a felony offense has the right and is legally required to have the case presented to the Van Zandt County grand jury before an indictment can be issued and the person can be prosecuted for the offense. However, an individual who is accused of a felony offense can ask the court to allow that person to waive the requirement to take the case before the grand jury for consideration and to allow the state of Texas to prosecute them on the filing of an information. Is that what you would like the court to authorize in your case?
Yes, sir.
And you understand that you're the only one that can waive your right to indictment. Mr. Merleader can't do it, Ms. Heisel can't do it, and I can't do it.
Yes, sir.
And you understand that by waiving that right of indictment, your case will not have been presented to the grand jury, and they would not be making a determination of probable cause. You would rather be stipulating that that there is probable cause and that the state can prosecute you on an information.
Yes, sir.
And you discussed your waiver of that right with your attorney, Mr. Merleader. Is that correct?
Yes, sir.
And while we're talking about Mr. Merleader, are you pleased with his representation of you?
Yes, sir.
Feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
And Mr. Merleader, do you believe Ms. Coffey to be competent today?
Yes, Your Honor.
Ms. Coffey, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar 2.
Are you currently undergoing treatment or medication for that disorder?
I should be, but I am not.
Do you feel like the fact that you're not on your medications is in any way inhibiting your ability to understand the proceedings against you?
No, sir.
All right, the court's going to approve the waiver of indictment in this case and finds that Ms. Coffey has intelligently, knowingly, voluntarily, and with counsel waived her right to indictment. Mr. Merleader, you heard Ms. Heisel read the court the terms and conditions of the plea agreement. Is that your understanding?
Yes, Your Honor.
All right, Ms. Coffey, you were originally charged by information with the third-degree felony offense of possession of a controlled substance in penalty group 1 gram to 4 grams. However, is that correct?
Yes, sir.
However, the plea agreement before the court is for you to plead guilty to a lesser included offense, a state jail felony, possession of controlled substance in penalty group 1, less than 1 gram. That type of offense carries a range of punishment of confinement in the state jail division of TDC for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
That means any plea agreement that you reach with the state or handed down by the court must fall within that range. At this time, Ms. Coffey, I'm going to ask you, how do you plead to that offense, that lesser included offense of possession of a controlled substance less than 1 gram?
I'm guilty.
And Ms. Coffey, are you pleading guilty because, in fact, you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court accepts Ms. Coffey's plea of guilt. Mr. Murleader, is there any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence. The court takes judicial notice of Ms. Coffey's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Just a few things, Your Honor. I've counseled Ms. Coffey on how slowly TDCJ is picking up inmates from the county jail. She's turning herself in today. And in addition to that, I've also counseled her on the state jail diligent participation program. And I've explained to her that if she participates in that program, the court will take into account her behavior and decide once the court gets notification from TDCJ whether or not to award her the credit for reduction on her jail time. She's been counseled about that.
All right, thank you, Mr. Murleader. All right, Ms. Heisel will give me a brief summation of the facts to support the plea.
Yes, Your Honor. Law enforcement was called out to a disturbance in van, and when they arrived, Ms. Coffey was sitting with her belongings on the side of the road. She had had a disagreement with her son. She was sitting on that roadside. The law enforcement officers noticed multiple signs that they believed could indicate intoxication by narcotics. They asked her for permission to search her belongings. They did, and did not locate anything, but one of the officers on scene did locate over near where Ms. Coffey had been sitting a bag of methamphetamine. Ms. Coffey denied that it was hers. However, when the officers reviewed their body cam footage, they clearly saw on video Ms. Coffey placing that bag of methamphetamine in the area where it was located.
Mr. Murleader, any objection to that summation?
No, Your Honor, that's correct.
All right, then based on the evidence before the court will find that there is sufficient evidence to convict Ms. Coffey of this offense. The court will follow the plea agreement in this case. The court hereby convicts Kelly Coffey of the possession of controlled substance, penalty group 1, less than 1 gram, state jail felony. The court assesses her punishment at 18 months confinement in the state jail division, assesses a $1,000 fine, $180 restitution, $290 court costs, orders a reimbursement of fees in the amount of $765, and awards Ms. Coffey 33 days jail credit for the time that she has spent in jail on this cause towards her incarceration sentence. Ms. Coffey, the court does entertain the diligent participation credits request when prompted by TDCJ. I have both granted those requests and denied those requests. And in doing so, I review all of the information that's provided to me regarding disciplinary history, education, progress that's being undertaken while in TDC. So if you are down there, you are diligent in your participation, there's no disciplinary actions, and your education is progressing through the courses, then the court does take that under consideration. Okay. All right, Ms. Coffey, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff to be fingerprinted. And once you get out of state jail, Ms. Coffee, you're going to need to report to the Van Zandt County Courthouse so you can make arrangements to discharge the money that you owe for your fines, fees, and reimbursements. Your failure to do so will result in the court issuing a warrant for your arrest. Okay?
Thank you.
You're welcome. Good luck to you.
Are we off the record for this case, Your Honor?
But off the record, do you mean off the court's official record or off YouTube or?
Court's official record. I just wanted to explain the plea a little bit. She was enhanceable, which is why the state offered her 18 months in this case. So could have been enhanced to a second degree.
Okay, well, I appreciate that. I just assumed that you are zealously advocating for your client, and the state's doing the prosecutors are doing the same for the state. So when I see those kind of plea negotiations, I understand that there's a lot of things going on behind the scenes that, of course, not aware of.
Thank you.
Bailiff, is Justin Richard Grubbs there at the jail court? Yeah, I didn't mute you. Let me see if I can unmute you. Ms. Heisel, did you break it? You did. Ms. Burns, I'm going to send you out to the waiting room and bring you back in, and maybe that will reset the issue we're having. So just stand by. The light up here, I get this nice little shiny spot on my head.
And the glasses too.
That's better. Usually I get this on the glasses. Like I got wide eyes like that.
They can't see your eyes.
Yeah. Let's try it again. Let's try
They
it
can't see you rolling your eyes.
We have-
Judge, if it pleases the court, can we just proceed on my laptop?
It pleases me very well.
Okay. Deputy McLeish asked me to tell you that Mr. Grubbs is here, and she ran to the back.
Okay.
Okay. And Ms. Burns would like me to relay to you that Mr. Grubbs is being tested as requested by the court.
Thank you. I appreciate that.
Mr. Adams? All right, and Judge, we've got Mr. Adams ready for his plea.
All right, step on up, Mr. Adams.
Yeah, don't go ahead, I'll stand right here. So she's gonna be right here.
Okay.
And Mr. Murleader, what's the name on this? I'm not seeing it on my docket.
Judge, it was added last minute. It's a pre-indictment plea for James Derrick Adams Jr.
All right, hang on. James Derrick Adams Jr. And what's the cause number?
CR 20-00279, Judge.
Okay. What's the term?
Your Honor, this is a third-degree felony possession of controlled substance, PG1, between 1 and 4. Upon a plea of guilty, the state is going to recommend punishment be assessed. 3 years confinement in TDCJ Institutional Division, $180 restitution to DPS. State is agreeing to waive the fine, but there is court cost of $290 and reimbursement fees of $15.
How much is the reimbursement?
Should be 760.
Well, this is TDCJ, that might be why. Let me make sure. Let's see. The attorney, please, Judge, the attorney's fees did not get put on the judgment here. If we could have just a moment to work that out.
Well, let's discuss that for just a moment.
Okay.
He's going to the Texas Department of Criminal Justice. I don't know that we can assess him attorney fees if he's been found to be indigent.
Okay. That's probably why Miss Abney left them off then.
Yes, I believe. So what are the reimbursement fees? Is it 25 or 35?
It's 15, Your Honor,
Okay.
and 159 days jail credit.
That's nice.
So, what would you able to-
And Mr. Adams has waived indictment, is that correct?
That is correct, Your Honor. Let me make sure the waiver is attached. Yes, it is.
Okay. All right, Mr. Adams, if you will, raise your right hand. Mr. Adams, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So if you got it.
Yes, sir.
Okay, you may put your hand down. Mr. Adams, do you understand that you have the right to have your case presented to the grand jury, for that grand jury to review the evidence and determine whether or not there is sufficient probable cause to move forward with a prosecution of the accusation in your case?
Yes, sir.
Do you understand that you, as the accused, have the ability to waive that right to the grand jury, and only you can waive that right? Do you understand that?
Yes, sir.
You understand that by waiving that right may not be restored to you, and that the state could prosecute you on the filing of an information, such as in this case.
Yes, sir.
And you're asking the court to allow you to waive your right to indictment.
Yes, sir.
And are you doing so intentionally, knowingly, and voluntarily?
Yes, sir.
Meaning no one has pressured you, forced you, otherwise told you you had to waive your right to indictment?
No, sir.
Okay. And Mr. Adams, you are represented by Mr. Murleader. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had sufficient time to discuss your case with him, have all your legal questions answered?
Yes, sir.
Mr. Murleader, you believe your client to be competent today?
Yes, Your Honor.
Mr. Adams, have you ever been diagnosed with any type of mental conditions?
No, sir.
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And Mr. Murleader, you believe that your client intentionally, knowingly, voluntarily is waiving his right to indictment?
Yes, Your Honor.
All right, the court will approve the waiver of indictment. in this case. And Mr. Adams, you heard Ms. Heisel read the terms of the plea agreement. Is that your understanding of the plea agreement in this case?
Yes, sir.
Mr. Adams, the range of punishment for a third-degree felony offense is confinement in the institutional division of TDC for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that that is the range of punishment for which the state can make a plea offer or the court could render a sentence?
Yes, sir.
All right, I'm going to ask you then, Mr. Adams, at this time, how do you plead to the third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams?
Guilty.
And Mr. Adams, are you pleading guilty because, in fact, you are guilty of that offense?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept Mr. Adams' plea of guilt. Mr. Murder Leader, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Adams' judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor. Just like with the last defendant, I've counseled Mr. Adams on how slowly TDCJ is picking him up. And with a 3-year sentence, he might be paroled from the jail itself. I'm not exactly sure. He understands that.
And he understands that's going to be decided by the Court of Pardon and Parole.
Yes, sir.
Okay. All right, Ms. Heisel, can you give me a brief summation?
Yes, Your Honor. Mr. Adams was one of a couple of suspects in a theft from the Dollar General. When they made contact with Mr. Adams and ran his driver's license, they discovered that he had a pardon and parole warrant out. So they placed him in custody for that warrant. When they placed him in custody, he volunteered to the officer that he had drugs on his person, and a black drawstring bag was retrieved from his pants that contained a bag of methamphetamine.
Any objection?
No, Your Honor, that's correct.
All right, then based on the evidence before the court will find that there is sufficient evidence to convict Mr. Adams of this offense. The court will follow the plea agreement reached between the parties. The court hereby convicts Mr. James Derrick Adams Jr. of the third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than 4 grams. The court assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice. Orders him to pay $180 restitution, $290 court costs, $15 reimbursement fees, and awards Mr. Adams 159 days credit for the time that he has spent in jail on this cause. Mr. Adams, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence and have you step to the left to be fingerprinted with the bailiff. When you are released from TDC, it's important that you contact the court compliance officer here in the courthouse to discuss paying off the fines and fees and restitution that you owe the county. Failure to make that contact and work out some kind of agreement, payment plan, or paying in full, whatever it be, failure to do that will result in the court issuing a warrant for your arrest. Okay?
Yes.
All right. Step to the left of the bailiff.
Yeah. We'll get a copy of that. Thank you, Your Honor.
Thank you, Mr. Murray. That's all you have?
I have one MTR. He's going to be brought in later, I guess.
Is that
Next, okay.
Mr. Simmons?
That's correct.
Okay, thanks.
Come on, Judge. You need to speak with him? Okay.
I don't. Thank you.
Take him to the room.
All right.
Judge Martin,
Yes.
we have Mr. Justin Grubbs here. I just walked in, so I don't know what the status of Mr. Ashmore is, but anyway, while we're waiting for one of the other inmates, if you'd like, we do have Mr. Grubbs here.
I'm bringing Mr. Ashmore in.
Okay, Mr. Grubbs, come on up to the podium, please.
Okay.
Ms. Burns, I know Mr. Waddell was working with him. Is there anything?
All right, Mr. Ashmore, are you there?
I am, Judge. Thank you.
All right, and can you see your client, Mr. Grubbs?
I can.
Mr. Grubbs, can you see your attorney, Mr. Ashmore?
Yes, Your Honor.
Yes.
Okay. All right, this is in cause number CR 20-164, State versus Justin Richard Grubbs. Mr. Grubbs was set on the 9 a.m. morning docket and failed to appear at that time. Court was notified that Mr. Grubbs stated he was unaware that he was required to be in court today. Contacted the court, and the court instructed him to be here at 1:30 on the 1:30 docket. And we are set for pretrial, Mr. Ashmore. Do you have any contested pretrial motions in this case?
I do not at this time, Your Honor, and I'm not sure that there will be. The state and I have conferred about a plea offer, and I have not had a chance to visit with Mr. Grubbs about that yet. I was anticipating on seeing him today. Just so the court's aware, if memory serves, and I don't have my notes in front of me, I think it's 7 deferred with a $3,000 fine is the plea recommendation from the state of Texas. And simply would request that the court let us have at least a docket call to visit with my client, and then come back and make a decision on whether we're going to accept that plea offer or not.
Okay, the court finding that there are no contested pretrial motions hereby sets Mr. Grubbs for docket call. I'm trying to see, Mr. Ashmore, if I have set you.
I think November 5th at 9 is our.
Do you feel like that gives you enough time, Mr. Ashmore? That's three weeks.
I think it does, Your Honor.
I'm fine with that if you are.
I am, and something that I need to inform the court about that I was just informed about is that we have been told that we are number 1 in the 439th District Court on that Monday. I don't think that will be a problem. It's a bench trial. I can't imagine it's going to go more than 2 days, but things being what they are with other hearings and, which take precedence over civil trial docket. I just wanted to inform the court that if that comes up, we'll get a motion on file so it does not interfere with Your Honor's business. But I wasn't aware of that when I was there this morning.
Okay, well, we'll maintain the Thursday, November 5th at 9 a.m. for docket call for Mr. Grubbs.
And Mr. Grubbs, you understand that November 5th at 9 a.m., right, sir?
Sir.
Okay. We will be calling you later this afternoon. All right, my friend?
Okay.
Okay.
And so hang on, Mr. Ashford. So Ms. Burns, are you there?
Yes, I am.
All right. And I asked your department to undertake a urinalysis of Mr. Grubbs. Has that been completed?
It has. We did test him, and he tested positive for meth and marijuana and signed a UA option form that he last used this morning.
Okay, repeat that to me again.
He signed a UA option form that he used this morning. He tested positive for meth and marijuana.
Okay. Mr. Grubbs, the court finds that you have violated the terms and conditions of your pretrial release. Court hereby finds your bond insufficient in this case and orders your rearrest and sets new bond in the amount of $100,000. Bailiff, you're to take him into custody at this time, and I will provide an order of commitment to the jail as soon as possible.
And Judge, I assume that because Mr. Grubbs did appear this afternoon, that this morning's NISI has been withdrawn.
That is correct. The court hereby withdraws the judgment NISI issued earlier this date and withdraws the order for an alias capias. Court will issue rearrest on the basis of violation of pretrial release conditions. All right, thank you, Mr. Ashmore. You're free to go.
Thanks, Judge. You have a good afternoon, and
Thanks, sir.
apologize about the behavior of my client. Thanks for allowing me to appear by Zoom, Your Honor.
Well, you weren't there with him, were you?
You know, Judge, I did think about stopping on the way back for a hit of both of those substances, but I elected not because I want to stay in good standing.
Good for you. Good for you. You have a good day.
Thanks, Judge.
Hey, Danny.
That emoji.
Looks like we reset at 3.
We'll just reset it for free, and the next year we'll show off and we can get the paperwork done. Oh, I've already signed it, okay.
All right, Mr. Murray Leader, is this Mr. Simpson?
That's correct, Your Honor.
All right, this is cause number CR 15346. The court has reviewed Mr. Simpson's request for court-appointed counsel on the basis of indigency. Court has found him to be indigent and has appointed the Honorable Shravnesh Muraleader to represent him. Mr. Simpson, you've met Mr. Muraleader today, and I'm assuming, Mr. Muraleader, you are not prepared to go forward with Mr. Simpson's motion to revoke. Is that correct?
Not at this time, Your Honor. We've received a plea offer of 3 years TDCJ, which Mr. Simpson has accepted. We would just like to reset that to another court date for a plea.
Would you be available next Thursday on the 22nd?
I would not, Your Honor. I'm preparing for a bench trial on October 26th, and I'm meeting with experts that day.
What about the 20th, October 20th?
No, that should be fine.
All right, then the court will set Mr. Simpson for plea on Tuesday, October 20th at 1:30 p.m. All right, we'll see you on the 20th, Mr. Simpson.
Yes, sir.
Thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, thank you, Mr. Murleader.
Just leave this with you.
So does the Shire, the first half of that movie, second half is California. Action. All right, I'll see you guys. Shoot, how Captain Carter. Okay, shoot, okay, look that one. What the fuck?
Are we?
No, we're
No.
not.
Hold on.
Mr. Parrish, are you ready? We'll have to get you unmuted.
There we go. We're unmuted. Your Honor, I'm ready. How are you this afternoon?
Doing fine, sir. How are you?
Doing good. Thank you very much.
I read your motion. Is it my understanding that there's an agreement between you and the state to set bail on this case at $10,000?
I have no idea. What I can tell the court is that I had a conversation with Ms. Curry with respect to Mr. Gray. Mr. Gray, stand on up. He has got and this was before the motion to revoke was filed in his case. Mr. Gray has, I believe, in the motion to revoke that was filed, 2 technicals, and then there is a marijuana offense out of Gregg County that we are representing him on. I talked to Ms. Curry about a bond for Mr. Gray in the event a motion to revoke was filed against him in this county. That way he could potentially make a bond, and then I can figure out what we're doing in Gregg County, and then they get this case resolved. She was open to that. I asked her, well, what kind of bond would the judge be okay with? That's where I came up with $10,000. After that conversation, the motion to revoke was filed. It was filed as a no bond. Once I saw that it was filed as a no bond, I filed a motion, and here we are today. Mr. Gray turned himself in voluntarily to the jail. Once I was aware of when the warrant came out, I have some additional testimony I think we probably ought to put on the record with respect to Mr. Gray's health and some issues he's having with medication that I think would be pertinent for the court to have on the record in setting a bond on this case. But I am here on a motion to set a bond. You are the court that has to set it. And we are asking for a $10,000 surety bond, and I do have a witness for the court.
And what's the state's position? Is Ms. Heisel in there? Oh, I'm not asking you. I was asking this.
Sorry, Judge. Yes, Judge, the state is in agreement to the $10,000 bond, and we have no objection to Mr. Parrish putting on any testimony he feels like is necessary for the court to hear.
Okay. It's being the court's policy and understanding of the law that as being on straight community supervision, that Mr. Gray is not entitled to a bond. However, the Texas Constitution grants the court the authority to set a bond in a discretionary manner. The court will find that the setting of a $10,000 bond would be reasonable pursuant to the agreement of the state of Texas and Mr. Gray in this case. Court, even though it's the court's conditions of community supervision, the court still views it as the state's case. So I don't need additional testimony, Mr. Parrish. If you want to put it on, you're welcome to do it. However, the court is fine at setting bail on the recommendation of the state at $10,000.
Thank you. Thank you very much, Your Honor. And just for purposes of the record, the testimony that would have been put on would have been with respect to a breathing condition that Mr. Gray has. They gave the jail some medicine that he has not had in 4 or 5 days. I believe it was lost, and they're having issues getting a refill. I think once he's out, they'll be able to get that handled. But we'll take care of our business in Gregg County as well as this county, Your Honor. So I appreciate the court's time.
You're welcome. So the court's setting bail at $10,000 cash or surety, and the court is signing the order provided by the defense this day. I'll have that sent to the jail, Mr. Parrish.
Thank you very much, Your Honor.
You're very welcome. And let's go ahead and we need to go ahead and set Mr. Gray for an additional hearing on his, do we already have a setting, Mr. Parrish, that you're
Your
aware
Honor,
of?
we don't have a setting. I'm obviously not asking for a speedy hearing. I'm trying to get Gregg County sorted out. That case has not been indicted up to this point in time. It's alleged it's a marijuana offense out of Gregg County is what the allegations are. That hasn't even been indicted up to this point in time. So I'm trying to handle Gregg County before we resolve this situation over here.
What would you guesstimate on how long you
if we could have 60 days and maybe set it for a status hearing just to see where we're at, I would appreciate that.
Any objection by the state?
No, Your Honor.
Just looking over my schedule. Mr. Parrish, are you available on December 8th or 10th?
I will be.
All right, let's set this for December 8th at 9 a.m. If Mr. Gray does not make bail, it would be at 1:30 and he would remain in our custody. If he does make bail, then it would be at 9 a.m. And Mr. Gray, you need to understand that just because a motion to revoke has been filed does not alleviate your requirements to report and comply with all of the conditions of your community supervision. So drug education, reporting, paying, abstaining from the use of harmful substances, whatever's in your conditions of probation, you're still ordered to abide by those. And I don't want to speak for Mr. Parrish, but I think the more you abide by those and the better you do is probably going to put him in a better position to advocate for you in this case. You understand? So if I get, I've set your bond at $10,000 today because you've asked for it and the state's agreed to it. But if you do not report next month like you're ordered to do, then I'm just going to issue another warrant for your arrest, and we won't have any more bond hearings. You'll just be held without bond. However long it takes Gregg County is however long it takes Gregg County. You understand?
Yes, sir.
Okay. So December 8th, 9 a.m. If he's on bail, December 8th, 1:30 if he's in jail.
Thank you very much, Your Honor.
You're welcome. Thank you, Ms. Parrish.
Yes, Your Honor.
Mr. Manning, are you ready? You're on mute.
Yes, Judge, we're ready on Mr. Dupree. I think we have an agreement with the state.
That's correct, Your Honor. I spoke with Ms.
Is
Burns.
Mr. Dupree in there?
No, Judge, we reached the agreement. If you like, we can have him be brought up. It's to dispose of his case today.
Is it what's the agreement?
Judge, we're going to dismiss the motion to revoke, and we're also going to ask the court to terminate his probation. He has paid his balance that he owes Van Zandt County in full. There's also an allegation in the motion that he failed to report, but he was reporting via mail from Louisiana. So we're going to be filing a motion. I've already got it printed out and signed. I just need to e-file it and or send it over to the court with Deputy McLeish this afternoon. But we're asking the court to dismiss the motion to revoke and terminate his probation.
That's our understanding, Judge.
My only concern is I'm not going to have him on the hook to pay for Mr. Manning's legal bill. How are we going to handle that? Because if he's terminated and dismissed, I don't have personal jurisdiction over him anymore.
Judge, I'll waive fines on him, or I'll waive my fees on him.
Well, let's don't do that. Why don't you speak with him to see what he can afford to pay?
Well, Judge, I just met with him at a point this morning. I just met with him, and he just paid all his money that he had to get caught up on the fines and court costs. So I don't mind at all. I'll just write this one off.
Pro bono.
That's right.
Okay. That's fine.
Okay, thank you, Judge.
Mr. Manning, is this Mr. Crocker?
Yes, it is, Judge.
All right, this is cause number CR 19-229, 240 and 240, I'm sorry, 240 and 241, State versus Evan Ray Crocker. And I believe that we're set for arraignment on 2 of them and a motion to adjudicate on 229. Is that correct?
That's correct, Judge.
Go ahead.
Judge, I've gone over the new charges with Mr. Crocker. We waived the formal reading of the indictment. His name is spelled correctly. He understands the charge against him and at this time enters a plea of not guilty.
All right, the court will enter Mr. Crocker's plea of not guilty into the record in 240 and 241. And I'm assuming, Mr. Manning, you're wanting the court to set pre-trials and continue the MTA with the pre-trial. Is that correct?
That's correct, Judge.
Are you available on December 8th or December 10th?
I can check. I am free on December 8th, Judge.
All right, let's set these matters for their respective pre-trials on the 2 newer cases and MTA on the 229 case for Tuesday, December 8th. Of course, if looks like if Mr. Crocker is going to be continued in custody, it'll be at 1:30. Otherwise, if you make bail, Mr. Crocker, it'll be at 9 a.m. in the courtroom.
Just sign it. This is recognized and show back up. These 3 keys. And then today's the 15th. Yeah. I think I've got it on Discovery. I haven't had a chance to do videos. I don't think. Stephanie may have those done by now. But I have gotten on the paper Discovery and I've gone over some of them. I believe that concludes our business with Mr. Crocker. May he be excused?
Yes, he may. Thank you, sir.
Thank you.
Mr. Manning, did you get my text message?
I did, Judge.
Okay, good.
I will, I'll swing by the courthouse.
All right.
Can I take a picture real quick? Because otherwise I forget it.
Right, I believe that concludes our afternoon docket. Anything else that the jail needs?
No, sir.
You're good to go? All right, thank you, sir. Appreciate your help today.
All right. Did we get paperwork for Mr. Grubbs back?
Not yet.
It's on its way over.